was, the words, if the bill will fall through, must be understood in this way. The governor withholds assent and refers invokes the first proviso, sends it back to the legislative body. The court declares the law of the bill. 52 ruling and the 2000. അല്ല ഇതിൻ്റെ അകത്തുള്ള paragraph 300. The decision in this case was a step forward. They are referring, and the court said, peril to democracy or democratic principles, bias is inherent and or manifest in the advice of the Council of Ministers. Council of Ministers disables itself or disentitles, and there would be a complete breakdown of the rule of law. And then that paragraph, last sentence, Article 200 being a provision where the governor must act on ministerial advice as a general rule, the aforesaid exposition would squarely apply to this provision as well, thereby severely curtailing any possibility of exercise of discretion by the governor. And thereafter the court in fact goes on to say something which I will presently come to. So the third exceptional case, you may only take it for the present, consists of actions or laws which may pose a peril to democracy, danger to democracy. Now, again, this is a matter where I have my own reservations, with the greatest of respect. Today in the country, generally, there is, from what I could make out, the Chief Minister of Tamil Nadu included, was heard saying that it's a great victory for state rights. It is undoubtedly, that I'll come to, makes a great advancement of the law for various reasons. But I was a little concerned as a student of law, with the greatest respect. If a bill which is passed by the legislative body of the state, and advice is given by the Council of Ministers, if it falls within the discretionary power of the governor to decline assent or withhold assent or refer to the president on the ground that it is peril to democracy or that the advice is biased, all those things which I mentioned, rule of law breakdown, I am a little worried that in the future there might be governors who might use this as a handle to hold up legislation by the states. Because it is said that this is one of those areas, of course, the court has been very careful in dealing with the possibility of its abuse when it comes to judicial review, justiciability, how it should be done. It has been elaborately laid down. Once the court actually found that 7 judges bench in Shamsher Singh lays down the law that aid and advice is indispensable and it is binding. The judgment in Madhya Pradesh Special Police Establishment case was not a case dealing with legislative power. Why I say this is, apart from the fact that peril to democracy might appear to be a little overbroad, in the sense that democracy itself has got a lot of connotation. You have a political, like an agent of the central government. There could be, very situations which might attract it. Generally, I would think that the principle which was essential for the purpose of an administrative law or quasi-judicial, like granting of sanction, may not be apposite in the context of a legislative enactment. The second reason I say is it open to challenge a law on the ground of mana fides? I think it is settled law, it is not. is not one of the grounds on which you can challenge the law. Is it possible for you to successfully attack a law on the basis that there is bias? It is not possible. So if the cabinet were to have bias, or if it is having malafidis, or it make out some element of a democracy, and if governors were to make use of it and hold back legislation, I would only wonder, I mean, whether if it does not get to be used by the right kind of people in the right situation, maybe you can think of situations which may be relevant. So this is what, as far as the governor's discretion is concerned. Now you come to the question of timelines. This is a very important aspect which has been evolved by this decision. It's a seminal decision in that regard. It has come in for criticism. Political parties of a particular hue, particularly, have taken it upon themselves to criticize the fixation of timelines. But let us see the facts. The resentment against the governors is not of recent origin, as I have mentioned. Things got so bad within the first 25 years of our republic that in 1978 you had to have the first Secretary commission on state. Whereas I said, some of the parties didn't want to have the governor anymore. He is a burden. So what did the Secretary Commission say? As I have mentioned, Secretary Commission recommended even at that time that you should have timelines. Now, the most important aspect about timelines which have been evolved in this particular case is this. In Pakistan, the Pakistani Constitution, Section 75, provides that the law is passed and if it is not done within 10 days, it will become law. So that's a kind of, you put a gun to your head and say that you do it within this day, and if you don't do it, the consequences, it will become a law. What Justice Pardiwala is at pains to point out, and in my humble submission completely correctly, is that the law, the timelines which the court has evolved does not have this gun to the head aspect. It only, first of all, it has been evolved only because there is no other way to deal with these governors. The way the governors have been acting, I mean, of course, we are all lawyers and we must use the most dignified language. But to arouse the Supreme Court to make caustic remarks about the governor, you can imagine, I have mentioned the facts in the very beginning, how they acted with alacrity the moment the Supreme Court issues notice. Otherwise, they'll slumber over it as long as they want. So this is the attitude of the governors which have been, this goes to, the question of appointment of governors. What kind of people will you appoint? Sarkaria Commission had made several recommendations. Punji Commission has made recommendations. What kind of people you should appoint? You can't, to satisfy disgruntled elements in your political party, pick and choose political elements who have no idea, clue about the working of the Constitution, who will do the bidding of the master. The Supreme Court has in BP single, as you know, where the question was whether it is open to remove a governor. The Supreme Court has held that, yes, you can remove. In the course of the judgment, Supreme Court took care to point out 2-3 things. The governor is not an employee of the government of India. The governor is not the agent of the government of India. The governor does not represent any political party. He has to be an impartial arbiter when there is a conflict between the central government and the state government. So he has to be above all this, somebody who is above all this, somebody who has proved his mettle, who has proved his merit in some field. They are all, person who is dispassionate, who doesn't have any political allegiance. This is a background in which the court had to deal with several states, the same pattern, where the governors were sitting over the bills and doing nothing, thinking that the Constitution permits them that laxity, that indulgence, that they can get away with it. Nobody will pull them up. not this time around. This court is a very, very, very strong court. And if I may get a little personal, I believe Justice Pardiwala is going to prove one of the toughest nuts, if I may say so, in the coming years. He's so hardworking. I said I'm personal. He's so hardworking. I had the good fortune of being his neighbor. And he's a man who is, committed to nothing else but his work. That is kind of he lives that kind of a life of an ascetic. So I was on the timelines. So the timeline which is fixed by the court in this case is marked by one characteristic, which is that it is not gun held to the head. It does not, if it is breached, result in deemed assent. Please remember this. If the Supreme Court had instead said that we are fixing this timeline, if the governor does not give his assent, if this does not happen, this will happen, then this is virtually amending the Constitution in a radical way. The court goes on to say that we are not amending the Constitution in a manner which will militate from the substance of what the article provides, which means that once the bill is given to the governor for his assent, the governor is expected to take some decision. Shall assent, shall withhold, refer it to the president. So word shall, not may. So he doesn't have a discretion to take a decision. All that we are saying is, and that too following the Secretary Commission, the Punji Commission, and the most important thing which I must take into confidence is, in 2016, the Government of India itself issued 2 OMs, office memorandums, because the Government of India found that the President was actually sitting in, was not taking action within time. Not when you talk about the President, this is an opportunity for me to get over one more criticism which I heard. How can the Supreme Court issue direction against the President? How can the President be directed? How will you dare do that? Yeah, this is on the basis of complete misunderstanding. The President and the Governor they are only constitutional heads, figureheads. They act on the advice of the Council of Ministers, the centre or in the states. No doubt the Supreme Court has used the word direction to the President. It should be only understood as a direction to the real force behind the President. It is not as if it is a direction to the President. It is here that I will bring in Article 361 of the Constitution. 361 gives immunity to both the President and the Governor from actions being taken against them for something which they have done in their official capacity. It goes on to do many other things. Now, in Rameshwar Prasad's case, the case arising under Article 356, the question was raised as to whether, in view of Article 361, you can make allegations of malafide, of illegality by the governor when he was actually, instrumental in bringing about President's rule. There the Supreme Court said the whole idea of giving the immunity under Article 361 to the governor or to the President is, the President and the governor are only nominal constitutional heads. The real executive is actually the Council of Ministers and the executive. So when action is being taken against, it is only that it is taken in their names. That is why you are giving them the protection under Article 361. See the logic behind it, that you get immunity because actually you are not doing anything. It is all being done in your name, that's all. So you are getting that protection. But the court went on to say in Rameshwar Prasad that it is open to a litigant to file a case, but please don't put the name of the governor. Right? That has been the subject matter of a cost by the Supreme Court. I think to the tune of about 10 lakhs, I think Surendranath will be able to tell you. If you put the name of the governor, you are not supposed to name the governor as such, the office of the governor, something like that. But the real power, executive head, is the Council of Ministers. So I wanted to clarify those who criticize this judgment saying that you cannot direct the president, you can't direct the governor, they are not understanding that it is not really against the government, it is actually the direction is against the government, the Council of Ministers, which nobody can say you can't do that. I don't think we have reached that far so far. So, so far as fixation of time is concerned, it is my humble submission that the Supreme Court has not done anything which is wrong. On the other hand, I would justify what the Supreme Court has done as it will further the cause of democracy, further the cause of federalism, further the cause of rule of law, of good governance, because you must realize at the end of the day, the government of the day which sponsors the bills, which gives promises in their election manifestos that they will bring about changes which can be brought about only by making laws. And you have a 5-year term under Article 172 of the Constitution, as you know, as far as the state legislature is concerned. So within that 5 year, if there is a 356 declaration, even that is cut short. So the Supreme Court, legislatures are, racing for finishing their targets within the time allotted to them. So they make laws, it takes time. And by the time, at the end of the day, when you take it to the governor, whose role is very, very, very limited, as I have mentioned, if he is able to put a gun to you and say, we will not do anything, and it lapses, it is a complete, the direct attack on democracy that these governors have been doing is what I would say. Absolutely undemocratic, absolutely unconstitutional. So this time limits which have been fixed, I would give full credit to what the Supreme Court has done. They have done nothing which is wrong because of the fact that it does not contain any provision for deemed approval. Second aspect is that the fixation of time limit is important for the purpose of evolving the concept of judicial review. If you did not have timelines, as has been fixed in paragraph 250, you may read para 250, the timelines have been fixed, largely drawn from the Secretary Commission, even the presidential OMs which have been fixed. So it is nothing new. It's clear that it is linked with giving access to the state governments to go to the Supreme Court or the High Court and seek relief. So this is most salutary contribution by the Supreme Court by this judgment. Now, the next aspect is, what are the courses of action which are open to the President? Because in this case, as you know, when the matter went to the President, he dealt with the matter under Article 201, so therefore there was occasion for the court to actually deal with Article 201 as well. Now, Article 201 I have mentioned, the President can either grant or withhold assent, or he can remit it back to the Assembly through the Governor. This is the procedure. The State Assembly must take up for consideration within 6 months of the receipt of the reference. This is the provision. Now here the Supreme Court has again entertained the doubt whether actually the President would have the power to act as the Governor can act with the aid of the first proviso to Article 201. In other words, you see, as I mentioned earlier, in Article 200, if you withhold assent, you must always invoke the first proviso. You must send it back. This is the law. Now, if the President empowered to send it back, or if he withholds assent, can he or should he send it back? Here the Supreme Court has gone one step further and said, though the words as soon as may be, which is present in the first proviso to Article 200, is not there in the first proviso to Article 201, it ought to remit the matter to the State Assembly when it decides to withhold assent under Article 201 also. Thereafter, the court actually goes on to deal with the kind of circumstances in which the court judicial review can be entertained. This is the greatest kind of contribution by the Supreme Court in this regard, because it did not simply say timelines. So what if timelines are there? If there is no deemed defect, governors will again sit over bills with impunity. So the court has evolved. The court has said what should be done and how it can be done. Court said you can go to the concerned appropriate High Court or to this court, meaning the Supreme Court. Now the Supreme Court has given a six-fold division as to how it should be done when there is an occasion for judicial review. In the first instances, I have mentioned that if acting under the first proviso to Article 200, the legislature were to repass it, it is binding. Assent cannot be withheld if the assembly were to repass it. But the Supreme Court has been very careful in carving out an exception. What would happen if a bill is passed in a particular form and it is remitted back by the governor acting under the first proviso, suggesting certain amendments? Take an example which the court says of a bill which is passed again but which is completely different from the earlier bill. So in the guise of complying with the message under the first proviso to Article 200, when you are supposed to deal with certain incongruities or problems in the bill as originally drafted, you actually make use of this opportunity and knowing that you cannot be denied the assent when you do it the second time around, you give it a completely different hue, complexion and character, and then the Supreme Court says it can be referred to the President. In such a case, ordinarily, once a bill is passed, again by the legislature under the first proviso, and it is presented, the only thing that the governor can do is to give assent. It cannot refer it, reserve it for this is the substance of the matter. The exception is if you pass a completely different law in the guise of complying with the first proviso. Next, the Supreme Court has opened up another avenue for judicial review. In the second proviso, it is open to the President governor to refer to the President for his consideration and assent any bill which affects the High Court, endangers the High Court. Second proviso, it is compulsory. And the governor saying that this is a bill which will affect the jurisdiction of the High Court, affect it dangerously. The court has laid down that even in such a case, it is open to the court to seek judicial review by pointing out that actually it does not do so. Because, the governors are always hunting for some reason to, dilly-dally with, the law bills which have been passed. So you can approach the court. The next important thing is that in all these cases, the Supreme Court has mandated something very remarkable. The Supreme Court has said that the governors and the President must give reasons. Now, as we have understood, the duty that's in the order. But that is a far cry from saying that reasons need not exist in the file on record. So there is a difference between giving reasons and reasons existing on record, because what the court does in a certiorari is, as you know, they call for the records. So even if you have not given reasons in your communication, you can justify your action. But here the court has gone a step further to bring about transparency, accountability, so that the governors will feel obliged to think twice before they do anything which is contrary. The question was whether the states the governor should give a recent reference as to which law passed by the parliament is it going to fall foul of. So that when the assent is given, assent is qua a particular law. And if it is refused, the reasons are given. So that this process of giving reasons is another seminal contribution, is what I would say, which will go a long way in introducing stability, accountability in the office of the governor and also the office of the president. As I have mentioned, when you talk about governor and president, please don't think that it is a direction to them personally. If it is on this basis, a lot of misunderstanding and criticism has been lodged, which is not so. Then the next case for judicial, when he can do it, is the president may, the governor may, if he finds that there is a peril to democracy. I mentioned that this is one of the areas. Peril to democracy is another area which is important, because when there is a bill which is reserved for, on the basis that it is peril to democracy, the Supreme Court has said that you may seek a reference under Article 143. Because this is another area of criticism I have heard on the television. I do not wish to name the person, all of you know. He was complaining, how can you do it? What is the power under 142? It is a nuclear missile. I think he said something like that. It is not, it is without reading the real context, understanding the context and in what circumstances the power under Article 142 was invoked. I believe, with great respect, that such a statement was made. The power under 142 undoubtedly is to be exercised rarely. There's been a long raging debate, matter has engaged the attention of larger benches, because, over a period of time, it has been exercised fairly frequently. I'll give an example. We had the Commercial Court Act, which provides for pre-litigation mediation. So, it's a case basically of prospective overruling. So we said that it is mandatory, but we said that it's only from the date of the judgment. That's a case of prospective overruling. But 142 comes in aid. What does 142 say? 142 says, for the purpose of doing complete justice to the parties. Now, I have mentioned in what circumstances 142 has been used in this case. The limited purpose was that, faced with the consequence that the 10 bills were referred by the governor to the president in the teeth of the binding judgment in the state of Punjab, when the bills should have been given assent to, and the actions taken by the president were rightly set aside, because there is no other way, because he doesn't have jurisdiction. The only question was whether it should be sent back to the governor for his formal assent, because he would have had to just say that what would he have written on the file? He would have written on the file on the basis of the direction of the Supreme Court. The assent is given. The court, in those circumstances, considering the fact that the matter has been pending for such a long time, and the only way those bills could have been dealt with was to grant assent, said that in these circumstances assent is given. How on earth can it be said that is a case where 142 becomes a nuclear missile? I thought it was something more. So I would think that this criticism of the judgment of the Supreme Court perhaps is completely without any basis at all. So I've covered 142, 143. The court has delineated a distinction between judicial review and justiciability. You must always maintain, understand that. In a written constitution, you may take it that there is nothing like unreviewable discretion. Howsoever high you are, for example, when the President issues a proclamation to Article 356, Bommai, the 9 judges bench, has opened up, the doors of justice for the states to fight an illegal imposition of President's rule, even if the action is taken at the level of the President. Of course, it is again by the Council of Ministers. The governor may have a discretion when it comes to sending up a report under Article 356, because obviously it cannot take the aid and advice of the ministry against which the report is being sent. Now, I'm not talking about the monthly reports. There are reports which are to be sent from time to time. But when a report is to be made under 356, certainly he can do it on his own. There are areas, as I said, where the governor can exercise his discretion. The governor can, if actually he is acting bona fide, and if he is acting in accordance with proper bona fide legal advice, he can prove a vital link between the center and the states. It is important that for working the Constitution as we have it today, it may not be possible to say that we should do away with the office of the governor, because it's an integral part, like I mentioned in 160 in the legislature, his assent is necessary. But it is one thing to say that if all things are done in accordance with law, then the governor will play a useful role. And it is a completely different thing to say that governors act like employees, agents, representatives of the central government, which the Supreme Court has in clear terms said that it is not permissible. Now, the one area where the court in paragraph 366 says, in 366 the court says, you may read paragraph 366 and paragraph 434. The court says it will be ideal for the President to seek the advisory opinion of the court under Article 143. Again, in paragraph 434, in the conclusions part, it will be prudent for the President to seek advice under 143. Now, this is not a direction as such. It is only the court saying that, see, you can get an opinion, you can get an advice, you know the nature of the advice under 143, it's really not law as such. It is an advice given to the President on his asking. And again, when he is asking the President to do it, another criticism is that he is asking the President to do it. It is, though the court has formulated it as a direction to the President, it should be understood only as a direction to the real executive, namely the Council of Ministers. No doubt the advice given by the Council of Ministers it cannot be gone into by a court. That is part of the... But it's a far cry from saying that their actions are immune from judicial review on the various grounds. I will just refer to also the fact that on 3 grounds, the President also has been brought in by the court under the scope of judicial review. The one is when he withholds assent, which is required for the purpose of granting immunity, say for example under Article 31A and 31C, or for getting the assent under Article 254(2). The court says that if it is arbitrarily or malafide, if it is withheld, it shall be open to the state government to approach the court against the President, which means not the President. You must understand, as I mentioned, the cost title, you will be making the appropriate entry. Then, if there is inaction either by the governor, obviously this is one thing which must be troubling you. If the governor does not take action within the timelines which I am not going into, which has been fixed, you cannot knock again at the door.
The position and status of the judiciary, especially the Constitutional Court, Supreme Court, in the grand map of democracy under the Constitution. And I need not say that the sovereignty, the ultimate sovereignty is with the people, and under the Constitution, sovereignty is not given exclusively to either legislature, judiciary or the executive. That is the fundamental thing as far as our democracy under the Constitution. So ultimate sovereignty of the people is reflected in the Constitution. That's why our Constitution says we found it and given to ourselves. So that is first time in the history of Constitution history of the world. So when we say ultimate sovereignty of the Constitution with the people, definitely there cannot be any supremacy of the legislature without checks and balance. If you give supremacy, ultimate supremacy to the legislature without checks and balance, and if you understand that is the core element of our democracy, it's wrong. That fallacy will lead to a totally opposite situation of transforming the democracy into something else. It can be an authoritarian government or a clear, full-fledged fascist government. So, dear friends, keep in mind, the Hitler came to power through democratic process only, not through armed rebellion. So democracy, if you accept as the ultimate supremacy of the legislature, definitely that will be the period of democracy as Justice Ken Joseph just now mentioned. So this is the alpha and omega regarding the concept of judicial review, which is now opposed, not only opposed, on that ground Supreme Court is being insulted and rebuked, and all sort of stupid assertion of supremacy of the legislature in the name of the people, and such utterances by high echelons of executive, I did not say, mention the names, including Vice President. This is part of a well-orchestrated grand plan. That plan is to demolish or mute the judiciary and take away the concept of the power of judicial review from the Supreme Court and High Courts, so that you can manufacture consent among people, because people may think that, yes, we are the Supreme, and that's why we pass legislations through legislature, and MLAs and MPs are only our representative, so our will is reflected in the new act or new bill. So how can you unsettle it? This is a dubious, well-orchestrated plan to manufacture consent among the people in favor of authoritarian government and fascism. So please keep in mind, whenever we expose this agenda, we must be very keen on this aspect. Otherwise, we may fail, because some of us also think that way. No, we love the people. We are the supreme. So when we make legislation through parliament or legislative assembly, who are you sitting in AC chambers, one or two judges, to make unsettle this law? So this is a dubious attempt to manufacture consent in favor of fascism. Please keep in mind, the power of judicial review asserted by the Supreme Court, restated by the Supreme Court from time and again, in the given context, in the context of our constitution and democracy, is the basic anchoring point of our democracy. And if you are not able to save this power of judicial review, Indian democracy is out. please keep in mind. And of course, I congratulate Kerala unit of AILU to organize this program at right time and to get Justice K.M. Joseph for this purpose. Thank you, dear. Thank you.
It is time for interactive session. Those who are present here can come to the dais and raise their issues, ask questions, and put their views on what was delivered earlier. Please come. Join.
So I just want to clarify on Article 145(3). Just on that, whether the two judge bench can consider this question involving constitutional interpretation.
With your permission, I leave because I got to catch my next train for another program. Thank you.
Thank you.
Others can also join. Please come and air your views.
In Article 200, it's three courses are to be adopted by the governor. One is withholding, first is consent, withholding, and send it to the president. Then the proviso comes. The Supreme Court dealt with this issue, this proviso, from paragraph 201 onwards. Then there is a little confusion or less clarity in those areas. Three courses, proviso is exception to all these three. Giving consent, withholding, and sending it to the president. When the governor is withholding, is it necessary to send it back? And whether the proviso is applicable to the withholding of the assent. Proviso says that as soon as possible, the governor should return to the legislature with a suggestion for modification. In that case only, the legislature is given power to again repass it and send it back. Whether this proviso is applicable to the cases where the governor withholds the assent, that is my confusion. When withholds the assent, when he withholds the three courses, withholding, giving consent, and sending it to the president. And the proviso says that is totally different. That is accepted to all these three. When the governor, as soon as possible, to send it back with the clarification or modification, suggestion for clarification or modification. Whether this proviso is applicable to withholding. Withholding, the meaning of the word withhold is also examined in paragraph 201 and 2. And when withholding, whether it is necessary to send it back with the clarification or the proviso is applicable to this withholding. Am I clear? Am I clear?
Yeah, you are saying once it is withheld, they need not send it back.
Need not send it back. Need not send it. No. That will not apply. Proviso is not applicable to that. Yes, that's it. Proviso is not applicable to that. Whether proviso is applicable. Supreme Court added the words, saying yes, added the words. Not construing, not interpreting, but construing in a manner that adding some words that when it is withholding also, this proviso is applicable. In that area, some clarity is required, I think.
The question is whether a single judge or two of them has the power to declare the act of the government is null and void. Or another one is what assessment. Another one is whether we have a constitutional bench declaring about such rights. Is it necessary? A constitutional bench is necessary for the review of the constitution or constitutional acts.
I'll just read 145.2. It comes under the rules of the court. It says the minimum number of judges who are to sit for purpose of deciding any case involving any substantial question of law as to the interpretation of this code or for the purpose shall be 5. I think really I have not looked up this aspect, I must confess. I think it really speaks about the composition of a constitution bench. The earlier number was, I think it was 7. It was reduced to 5. So I do not think it is it's fatal to the composition of this 2 judges bench which rendered the judgment that it did interpret the constitution. If the court feels that a matter it does involve interpretation of the constitution, certainly the court could have done that. It would have been, in my view, it could possibly be said to be ideal. You must consider only one thing. In fact, I make use of this opportunity to air my view on this also. See, the practice in the Supreme Court is, in constitution bench matters, there are several matters which have not been taken up for years together. 9 judges, recently when Chief Justice Chandrachud took over, quite a few matters were taken up with greater expedition and disposed of. Otherwise, you refer it to the constitution bench and it will remain in limbo. This is the sad plight, and it is my personal view that Supreme Court, being the premier, the highest constitutional court in the country, should have a regular constitution bench, namely 5 judges, devoted to hearing constitutional matters as and when they come. 2 examples, one from our own neighboring country, Pakistan. The Pakistan Supreme Court heard the challenge where involved Imran Khan, I think, where not Imran Khan, the Prime Minister, who was it? Imran Khan. And it was disposed of within a period of, I think, 2 months. The English court, the British court, the House of Lords, which is the Supreme Court now, it dealt with a matter relating to Brexit. It produced a 30-page judgment, but then it did it within 1 month. So, if you refer it to the Constitution bench in a matter like, the governor's delay, what will happen is that, it will never get taken up. This is a big problem. So, the first thing I would answer by you is a suggestion that the Supreme Court should have a regular 5-bench matter so that no Constitution bench matter should remain pending for more than, say, 6 months or at the maximum for 1 year from the date on which it is received. So that will be a perennial. You can rotate it. You should give opportunities to all judges, and the matter is taken up and it should be disposed of. I have no doubt about it. But it will not affect the legality of the judgment rendered by this court. This is my view. Secondly, the question which was raised about withholding of the bill and then referring it to the assembly under the first proviso or the Article 200 or 201. See, I have told you that the concept of withholding in the context of giving assent or referring to the president, all these courses are courses which will finish the matter at one go. If assent is given, the bill becomes law. If assent is withdrawn, what the earlier court said in 1952 and 2002 I have mentioned, it will lapse. And if it is sent to the the governor's road is over. There is no question of president remanding it back to the governor. The assent of the president in a referred matter is sufficient. You don't have to have two assents. So it is for the first time, I believe, that in state of Punjab versus governor, the court took the view to juxtapose the requirement under the first proviso with the action of withholding assent. Now, this is evolved by the court, this meaning. I have told you, the meaning of withhold has been interpreted in this judgment as putting it on hold, suspending the question as to whether assent is to be given and linking it with lapsing only when after remitting it to the assembly under the first proviso, they did not resubmit it. This is the interpretation which has been given. Namely, withhold assent is not denial. In fact, in so many words, the court says in a particular paragraph. I have told you my views about it. Actually, if you withhold assent, the matter, according to the judgments which have been rendered, my understanding is that it would lapse. This is how the courts have understood it. Now, this is a new development. You see, in the field of constitutional law, as time goes by, there occurs situations, circumstances, personalities come on the stage which necessitate. You take, for example, the basic structure doctrine. I mean, you could amend the Constitution to Article 368. It is plain and simple. When the matter reaches the Keshavananda Bharati, the circumstances were such that the court felt that the Constitution as it was framed had an identity. You can't amend the Constitution to change the identity of the Constitution completely. So this is again evolved by the court. And today we have got about 23 or 24 features, basic features which have been identified by the court. Though you could criticize the court by saying 2 judges, wise men in the Supreme Court can say, or 5 judges sitting in the judges appointment bill unanimously, near in one person dissenting. It was struck down on the basic structure. You could go into the nitty-gritties of it, the individual cases, and find fault with it. But in a country like, for example, in Bombay, the Supreme Court evolved secularism is part of the basic feature. Federalism, equity, a rule of law, democracy in Indira Nehru Gandhi, it was already settled. So we need to have checks and balances is what the court has held. So this development, mixing the withholding of assent, which would have normally meant denial and would have been there, you are correct. But by adopting this creative interpretation, you ultimately achieve a far greater role, which is to see that the will of the people, ultimately, as I mentioned, this goes to the democratic spirit. Because democracy, the basic thing is that you have separation of powers, legislatures make laws, judges decide, executive executes. So this fine division of power, the most important power which is given to the legislature is to make laws. There are other functions which a parliament or a legislature function, discussion, debate about many things will come up. But making laws is the most important thing. If the governor is given by an interpretation placed on the word withhold assent, that you want to deny assent, the result is that the governors we have today, being from a political party which is different from that which is there in the state government, the result is that all these legislative exercise which is time consuming, meant to produce beneficial results for the population, ultimately for the people of India, we the people of India, all that will be lost. So despite reservations we may have, it may be said to be in alignment with the larger picture, larger good that is sought to be achieved. That's all. Anybody else has got?
I believe Shri had asked specifically
Correct. The Supreme Court has said that it is limited only to the first proviso, only to withholding.
But just the English plain literal reading of the first proviso, sir,
Ah.
I humbly prefer to disagree, because it doesn't say that. The Article 200 says the President, when it's given to the government for his assent, he has to do either with the assent or withhold, or he can send it for
Reserve it to the will.
consideration. And the proviso doesn't say that it's only in the case of withhold. It says when the governor has to give his assent, he can give him his suggestions of what amendments need to be carried.
Correct, you're
So
right.
it is not really a withholding of assent in the sense that.
No,
it's
if the president, if the governor assents to the bill, there is no occasion for sending it back.
Precisely, but
If the governor sends it to the president, then also there is no occasion for withholding it. It's only, that is what the Supreme Court reasons, that it is only when the governor decides to withhold assent that it should be. But what the court has said is, after withholding, see, if you withhold assent and the meaning of withhold is denying assent, then there is no bill.
it is,
Then there is nothing to be sent back because it lapses.
when you're.
This is the criticism, which is
After it is repassed by the legislature, that is after it is repassed by the legislature, if he continues to withhold and he's not doing anything about it, it probably dies, but now we say it is deemed to be passed.
it's deemed to be passed.
But the first proviso, sir, my humble
Yes.
interpretation of that matter is that it is not necessary that the governor has decided to withhold.
Absolutely.
It doesn't say that. It is that when he wants to.
This was
assent
the
also,
this
when
was
he
the
wants to assent,
this
he
was the
can
this
bring
was
forward.
this was the argument of the Attorney General, that the first proviso to Article 200 actually provides for a fourth alternative. The fourth alternative is that the Constitutional Assembly debates also, this was contemplated as essentially to deal with the situations where there is some defect in the bill which is being passed. Or, for example, it's a private member's bill, the defect is in the bill, there is an error, and that is detected. So, as you know, once assent is given, it becomes law. Then you have to amend the law. So instead of that, it's a preventive step. So without withholding, actually, see, there is another angle also to it. Supposing the advice of the Council of Ministers is to send it back under the first proviso. Don't withhold, just send it back. So what will you do with it?
Here's a
So
situation.
there, it's my personal view that it should be another opportunity without necessarily having to withhold assent. Without having to withhold assent, if the governor thinks that the Council of Ministers also advise, please send it back, let us correct it. So we must understand that the governors are aware that if they send it back under the first proviso, then it becomes a fait accompli, because the second time around it is passed. Assent cannot be, so they will never invoke the first proviso.
So that's exactly why the first proviso says, sir, that the governor can give his amendments, propose his amendments also.
Correct.
So
But
with that, it is not just it is not actually a withholding of assent in the manner.
no, you see, the government can recommend amendments.
No, the governor himself.
Governor can do that. But it is not necessary for the assembly to pass the law with amendments, with or without the amendments. Once it passes, assent has to be given. So governors know it. So what they do is normally they will simply withhold assent. In fact, the Tamil Nadu government in the 10 bills simply withheld, said assent withheld. No reasons, no message, because it did not accept the contention.
That
So-
was his political view. There can be governors, there have been governors in the past who have provided their suggested amendments,
Correct.
which may or may not be accepted by the
Correct.
assembly.
Absolutely
As
correct.
a result, there could be a better law. So
Correct.
it's not as if every returning is.
No, it is not. See, that is why it all depends upon. See, you should realize the act of returning, act of giving assent, act of withholding, sending it to the president, ordinarily it is to be done on the basis of aid and advice. So here we are dealing with the exceptional cases where the governor can act in his discretion. That is what has been delineated. For example, supposing in a case where you require, the governor thinks it is repugnant to an existing parliamentary legislation. The state government gives aid and advice, pass the law, give assent. There the governor has a discretion. Because if the law is passed, if he places the central law side by side with the state law, if it is irreconcilably repugnant, he cannot give assent, which the law will fail. So there, those areas of discretion, now new discretion parliament, I mentioned para 300, where the power is involved. So it is all well-intentioned to make the best possible effect here.
Thank you.
Yeah.
The vote of thanks പറയുന്ന നമ്മുടെ സംസ്ഥാന സെക്രട്ടറി ശ്രീ പ്രമോദ്
പ്രിയപ്പെട്ട അധ്യക്ഷൻ ശ്രീ ഗോപാലകൃഷ്ണൻ സാർ, വേദിയിലുള്ള അനിൽകുമാർ, അതുപോലെ തന്നെ ഇന്നത്തെ നമ്മളുടെ ഈ സെമിനാർ ഏറ്റവും ഉജ്ജ്വലമായി അവതരിപ്പിച്ച ജസ്റ്റിസ് കെ എം ജോസഫ്, അതുപോലെ ഇവിടെ സന്നിഹിതരായിട്ടുള്ളവർ, പൊതുവിൽ പുതിയ ഗവർണറുമായി ബന്ധപ്പെട്ട ജഡ്ജ്മെന്റ് ഉണ്ടായതിനു ശേഷം വലിയ തോതിലുള്ള ചില കോൺട്രവേഴ്സീസ് ആണ് ഉണ്ടായത്. അതിന് പുറകിൽ പ്രവർത്തിച്ചത് മറ്റാരുമല്ല, കോൺസ്റ്റിറ്റ്യൂഷൻ പദവി തന്നെ വഹിക്കുന്ന കുറച്ച് ഗവർണർമാരും അതേപോലെ തന്നെ ഇന്ത്യൻ യൂണിയന്റെ വൈസ് പ്രസിഡന്റും ഒക്കെയാണ് അത്തരത്തിലുള്ള ചില പരാമർശങ്ങൾ ഉണ്ടായത്. വന്ന ഒരു പ്രശ്നം, എ ന്യൂ ലൈൻ ഓഫ് ആർഗ്യുമെന്റ് ഹാസ് ബീൻ ഫോർവേഡ് ടു ദ എഫക്ട് ദാറ്റ് with the parliament holds absolute control over the legislation, and judiciary doesn't have any judicial review power in it എന്നുള്ളതാണ് വന്നത്. അപ്പോൾ പാർലമെന്റ് അംഗീകരിക്കുന്ന നിയമങ്ങൾ പൂർണ്ണമായി തന്നെ നടപ്പിലാക്കിക്കൊള്ളണം എന്നുള്ള നിലയ്ക്കും, മറിച്ച് ജുഡീഷ്യറി അതിൻ്റെ മുകളിൽ വല്ലാതെ പോകരുത് എന്നുള്ളതും ഇവിടെ വന്നു കഴിഞ്ഞു. അപ്പോൾ അത്തരത്തിലുള്ള എല്ലാ വിഷയങ്ങളെ സംബന്ധിച്ചും വളരെ നന്നായി തന്നെ ഇവിടെ കൈകാര്യം ചെയ്തു എന്ന് മാത്രമല്ല, അവസാനം നമുക്ക് കിട്ടാവുന്ന ടേക്ക് അവേ എന്ന് പറയുന്നത് ഈ പറയുന്നത് പോലെ ജുഡീഷ്യറിയോ പാർലമെന്റോ അല്ലെങ്കിൽ മറ്റേതെങ്കിലും ഇൻസ്റ്റിറ്റ്യൂഷനോ അല്ല, കോൺസ്റ്റിറ്റ്യൂഷൻ ആസ് സച്ച് ആണ് സുപ്രീം എന്നുള്ളതാണ്. ഏതായാലും അത് തന്നെയാണ് നമ്മളെല്ലാവരും പറയുന്നത്. ദാറ്റ്സ് ദ റീസൺ വൈ വി ജസ്റ്റ് വാണ്ടഡ് ടു ഹോൾഡ് ദ കോൺസ്റ്റിറ്റ്യൂഷൻ ഈവൻ. അപ്പോൾ അത്തരത്തിൽ വളരെ അക്കാദമിക് ആയിട്ട് നടന്നു പോകേണ്ടുന്ന ഒരു ലെക്ചറാണ് ഇവിടെ നടന്നത്. അത് റെക്കോർഡ് ചെയ്യപ്പെട്ടിട്ടുണ്ട്. അപ്പോൾ അതിന് ടെക്സ്റ്റ് തീർച്ചയായും നമുക്ക് അവൈലബിൾ ആവും. അത് സാർക്ക് കൂടി കൊടുത്ത് എന്തെങ്കിലും എഡിറ്റ് ഉണ്ടെങ്കിൽ അതുകൂടി നോക്കിയിട്ട്, വളരെ പ്രൗഢോജ്വലമായ പ്രസംഗമായിരുന്നു. എല്ലാ ഭാഗങ്ങളും അതിൻ്റെ അത് ടച്ച് ചെയ്തു. സെൻട്രൽ സ്റ്റേറ്റ് റിലേഷൻസിനെ സംബന്ധിച്ച് പറഞ്ഞു, ഗവർണർ പവേഴ്സിനെ പറ്റി പറഞ്ഞു, കോടതികളുടെ പവേഴ്സിനെ പറ്റി പറഞ്ഞു, പ്രസിഡൻഷ്യൽ പവേഴ്സിനെ പറ്റി പറഞ്ഞു, ലെജിസ്ലേച്ചറിൻ്റെ പവേഴ്സിനെ പറ്റി പറഞ്ഞു. അപ്പോൾ എല്ലാ വശങ്ങളും ടച്ച് ചെയ്തിട്ടുള്ളത് കൊണ്ട് തീർച്ചയായും ദിസ് ഷുഡ് ബി ഡോക്യുമെന്റഡ് ആൻഡ് ദിസ് ഷുഡ് ബി പബ്ലിഷ്ഡ് അഗെയിൻ എന്നാണ് ഞങ്ങൾ ആഗ്രഹിക്കുന്നത്. അതിനുകൂടി സഹകരണം ഉണ്ടാകുമെന്ന് പ്രതീക്ഷിക്കുന്നു. ഇവിടെ വന്ന് ഏറ്റവും നല്ല രീതിയിൽ ഏതാണ്ട് 2 മണിക്കൂറിലധികം എടുത്ത് നമ്മളോട് സംസാരിക്കാൻ സന്മനസ് കാണിച്ച, അല്ലെങ്കിൽ ക്ഷമ കാണിച്ച, ഒരുപാട് തിരക്കുകളുണ്ട് അദ്ദേഹത്തിന്. അതിനിടയിലാണ് ഞങ്ങൾ പോയി സമീപിച്ചപ്പോൾ ആ സമയത്ത് തന്നെ അദ്ദേഹം റെഡിലി അക്സെപ്റ്റഡ്. ആകെ ഒരേ ഒരു കൺസേൺ ഉണ്ടായത്, ഇത്ര ഷോർട്ട് പീരീഡ് പോലെ കുറച്ചുകൂടി കൂടുതൽ സമയം വേണമെന്നുള്ള ഒരു ആങ്സൈറ്റി ആണെങ്കിലും ഞങ്ങൾക്ക് ഇത്ര കുറച്ച് സമയം കൊണ്ട് പ്രിപ്പയർ ചെയ്തതിൽ ഒരുവിധ കുഴപ്പവും തോന്നിയില്ല എന്നുള്ളൊരു ഡെഫിഷ്യൻസിയും തോന്നിയില്ല എന്നുള്ളതാണ് ഞങ്ങൾ അറിയിക്കാൻ ആഗ്രഹിക്കുന്നത്. വളരെ നന്ദി സർ. ലോയർ സംസ്ഥാന കമ്മിറ്റിക്ക് വേണ്ടി വളരെ നന്ദി. ബാക്കി ഇവിടെ സംബന്ധിച്ച് എല്ലാവർക്കും, നമ്മുടെ അഖിലേന്ത്യാ സെക്രട്ടറി സുരേന്ദ്രനാഥ് സാർ അടക്കം എല്ലാവർക്കും നന്ദി രേഖപ്പെടുത്തിക്കൊണ്ട് ഈ പരിപാടി അവസാനിപ്പിക്കുന്നു.
യോഗ നടപടികൾ അവസാനിക്കുകയാണ്. സംസ്ഥാന കമ്മിറ്റി അംഗങ്ങൾ സംസ്ഥാന കമ്മിറ്റി യോഗത്തിന് ആഹാരത്തിന് ശേഷം